Sometimes we think that these problems are only the problems of let's say, consumers or more vulnerable groups of people, but actually this incomprehensibility problem. This is also true for Wall Street investors and regulators, and for us, for lawyers, for people who draft contracts. For example, if I agree to some terms of use in the internet, I often, do not read, and if I wouldn't probably understand all the terms. And there is actually a lot of research about these subjects, and this is one example of that research by Wendy Wagner and Will Walker. So when the people who would need the contracts do not read or find or understand what the contract says, it's not only a problem for them, but it's also a problem for the writer. Of course, if you cannot understand the content of the contract, you cannot comply. You keep asking the same questions from the contract drafter, for example, and this all causes unnecessary risks and opportunities are missed. So definitely we need better documents, better legal documents, better contracts that work for readers. And we also need help in producing such documents, because it's not always easy for a lawyer, for example, to draft documents that are user-friendly. So then what has proactive contracting got to do with all this? First, short overview of the history of proactive contracting. So this approach was developed in collaboration by practitioners and academics in Finland at the end of 1990s. So basically, Helena Haapio, who I mentioned already, she used the term proactive contracting for the first time, if I remember correctly, in her 1998 conference paper. And around the same time, a Finnish academic, Soili Nysten-Haarala, she finalized her PhD about long-term contracts, and there she analyzed the gap between contract law and contracting in practice. And after this that year, so 1998, Haapio contacted Nysten-Haarala, and they joined forces, and then there were other people joining also, and so the story began, and then the first book on proactive contracting was published in Finnish in 2002. But after that, several international conferences were held, and many more books have been published also in English. Then I want to show you this figure just to illustrate that the proactive contracting approach is influenced by many research fields. So Haapio always says that, or highlights the influence of preventive law that was developed by Louis Brown, a lawyer, in 1950s in the US. So that's one side of or influencer of the proactive contracting approach, but then proactive contracting adds this promotive dimension to the preventive dimension, and I will discuss about that a little bit later. But in addition to preventive law, relational contract theory that was developed in 1960s has tremendously influenced this approach. But and then again also law and strategy, using the law for competitive advantage, and strategic business law and law and management, they have influenced proactive contracting approach, and they share very similar ideas. But in addition to these more legal approaches, transaction cost economics, which is an economic theory, then the relational view and the functional contracting approach, which are developed in managerial research, they have also influenced the proactive contracting approach. And then again, also legal linguistics, legal informatics, and design thinking, information design. They have influenced this approach. So it's very multidisciplinary field. Then something about the basic tenets of the proactive contracting approach. So the focus of the approach is on contract drafting and implementation, and some say that it's an ex ante view on contracting. So the focus is there, not on interpretation in dispute resolution. Obviously, the proactive approach acknowledges that the contract needs to be legally functional, also in the case of conflict, but the focus is not there. The focus is on contract drafting and implementation and interpretation during the contract execution phase. And then I already mentioned some words about prevention and promotion. So there are two dimensions. The preventive dimension that focuses on preventing undesired outcomes. So it acknowledges that there is a need to risk mitigation, but the promotive dimension highlights that contracts can also enable success. So these are the two dimensions, and while the preventive law was focused more on prevention, proactive contracting then adds this promotive dimension. Then the proactive approach acknowledges and makes use of the many functions of contracts, and I will show you an example of this. So this is from my dissertation, and what I want to highlight here is that normally lawyers and maybe people in general think that the most important function of a contract is safeguarding. So, and it means that the contract will safeguard the rights of the contracting parties against opportunism of another contracting party. But proactive contracting highlights that contracts are used for various other reasons as well. So for coordination, for example, adaptation, even for internal management. So a contract can be actually used for that as well. And maybe today we will focus more on collaboration, and also, if we have time, to this policy function. But the thing here is to understand that contracts are not simply legal tools to safeguard party rights, but also managerial tools to do much more. Okay, so let's go back then. So multi-professionalism, and here I want to show you a nice visual metaphor by Helena Haapio. So she uses this, for example, in her dissertation to show how contract is actually, how it consists of various parts that needs to be aligned and consistent with each other. And there is the legal part, of course, but in addition to that, there are various other parts, so technical part, implementation, financial part. And I think this highlights nicely the need for cross-professional collaboration during contract drafting, and also the various information needs of the people who actually use the contract. So it's not only by lawyers to lawyers, but also for other professionals, and if we are talking about business to business contracts, but also for other user groups, of course. So that was about multi-professionalism. And then finally, the proactive contracting approach makes use of information design research, principles and methods in contract planning. And what does this mean? It means in practice that the approach is informed by insights of information design research, meaning that the facts concerning, for example, literacy proficiencies of people, memory, how memory works, information processing and overload, and understanding are taken into account in the contract design process. And for example, regarding literacy, you probably know that there are different levels against which people can be scored. And well, there are various metrics to that, but one is this kind of that people are put against these levels, and level 3 is the minimum of understanding longer documents such as contracts. And around half of the people in most developed countries score below that level. And most of the lawyers, for example, we are in the highest 12%. So we are not in that half that score under level 3. So what we need to understand is that what is clear to us is not clear to most of the people. And oftentimes we tend to forget that, I think. Also, the proactive approach makes use of information design principles. So user centricity, for example, that means that the needs of the people who use contracts are the driving forces behind the design process. And then we also borrow methods from design science. So for example, experimentation, prototyping, and user testing. So those are the basic tenets of the proactive contracting approach. Then some real life examples of proactive contracting. And now I try to show you one website. Let's see how that works. So I think I need to stop sharing first, and then I will go to the web page. Just a second. And I will then start sharing again. Let's see. Okay. I will share now my entire screen, but I hope that, can you now see?
Yes, perfectly.
Yes,
Perfectly
we see.
visible, yes.
Okay, good. So here is a web page that is called Contract Design Pattern Library. This is designed by Helena Haape and Stefania Passera, the entire pattern library, I mean, and it's run by the World CC Foundation. World CC, World Commerce and Contracting, is an organization for commercial and contract experts. And this contract design pattern library, this focuses on user-friendly approaches to contract simplification and visualization. So basically how to make contracts more usable and understandable. And it uses a pattern approach, like is visible already in the name. And this means a pattern means a repeatable solution to a commonly occurring problem. So this is like you can explore this library by yourself after this webinar, but this means that there are models and examples to recognize a problem and develop an effective solution, but the pattern actually must not be followed, strictly, but you can then adapt it to your own context of use. But I will now go and show you one example of a pattern. So here, business terms first. This is a pattern that highlights the way of organizing contract content. Like I said, oftentimes lawyers, for example, tend to think that the most important terms are the legal terms. But for business people, this is of course not the case. And well, I think that without business, there wouldn't be the legal terms. So this pattern highlights the need to put the core commercial terms, sort of the active terms first, and the passive terms only later. And here is an example of how it can look like. This is example by Stefania Passera. So here the first part of the contract focuses on the business terms, and the second half of the contract document focuses on the legal terms. So maybe from guarantees onwards or so on, the document focuses on legal terms. And this design pattern library, I think actually it says somewhere here that it is based on the ideas of proactive law and proactive contracting. So this is a real life example of how to utilize this proactive contracting approach. I will now again stop sharing and start soon again for my presentation again. Okay. Just a second. So here. Can you now see again my presentation?
Yes.
Yes, so good.
Good. So then some current and future areas of application of the proactive contracting approach. So first, some words about collaborative contracts. So this term refers to different kinds of collaborative ways of doing work, and I guess this this term was launched by some consultancy companies around 10 years ago. But these can include, for example, alliance projects that are used especially in construction industry, then agile project models that are used in software business. And then one example that I want to show you actually is the vested model that is developed by the University of Tennessee Center for Executive Education. And that is targeted for highly collaborative business relationship regardless of industry. So here actually is, if you are interested, you can go to see this HBR article by David Frudlinger, Oliver Hart, and Kate Vidasek. And Kate Vidasek is the sort of the original developer or who first introduced this idea of this vested model and a formal relational contract. And the formal relational contract is, of course, inspired by the relational contracting approach. And like I said, it's an old theory already, but it has gained new momentum recently. And why? Well, Vidasek et alia, they have now developed this formal relational contract. And here it says that in this article, actually, that it is one that specifies mutual goals and establishes governance structures to keep the parties' expectations and interests aligned over the long term. And designed from the outset to foster trust and collaboration, this legally enforceable contract is especially useful for highly complex relationships in which it is impossible to predict every what-if scenario. Maybe one reason for this new coming is also that Oliver Hart, who won the Nobel Memorial Prize in Economic Sciences in 2016, he has embraced this view a lot. So this is just one model of this collaborative contracts. And in a way, all these models, like this alliance model and the agile project model, they share similar ideas with the proactive contracting approach and include elements of it. But when it comes to the actual design of such contracts, they are rather traditional. So they don't actually make use of these information design principles, etc. This formal relational contract model, it highlights the contracting process. So in that sense, it focuses on that as well. But the rest of the current models, they look quite traditional, actually. Okay, but then the second current and future area of application to the proactive contracting approach is the responsible and sustainable contracting, which we all, I think, agree that has gained some attention in, let's say, previous 5 years, maybe. So, like we have now learned, the proactive contracting approach highlights that the users should understand the contracts, and we also know that oftentimes, for example, the codes of conduct used by companies are written in a way that neither the drafters nor the users understand. And what I mean by this is that oftentimes the codes of conduct, for example, they refer to these international agreements, and then for example this ELO agreements and so on, and obviously not every lawyer even knows what's the content of those those agreements, and especially of course the users don't know that they are dealing with workers' rights, for example, and so on. So together with one of our research groups, we have launched this term sustainabilities to refer to sustainability jargon that can be understood by sustainability professionals and lawyers only. So I have co-authored an article with Juho Saloranta, and the article is called, at the moment it's accepted for publication by the Journal of Strategic Contracting and Negotiation, but it's not published yet, and its title is at the moment Proactive Contract Theory in the Context of Corporate Sustainability Due Diligence. And there we propose 4 avenues to put these very abstract sustainability obligations into actual business practices via proactive contracting. And now I will show you these 4 proposals shortly. So our first proposal is to turn from one-sided safeguarding towards shared responsibility and collaboration. Like I already mentioned, most of the contracts still focus on the safeguarding function, and many lawyers and many other contract professionals see that as the contract's most important function. But there is also research saying or indicating that this kind of contracting, especially if it's very one-sided, so that the rights of the party that has greater bargaining power, so this kind of contracting can result in underperformance and opportunism, and it can also hinder the creation and development of trust and flexibility and encourage conflict. So clearly there is a need to set relational or pro-social values, as some researchers call them, for the business relationship in the contract documents. And these values can include, for example, mutual respect, cooperation, reciprocity, trust, and loyalty. And I already showed you one example of this kind of contracting. So it was this formal relational contract. And the second example in the context of this sustainability and responsible contracting is the American Bar Association's model contract clauses. And those are meant for responsible buyers, so model contract clauses to be used by responsible buyers, and they recognize the power asymmetry between buyers and suppliers. So there's a working group, including, for example, David Snyder and then Sarah Dadush, and many others who have developed these model clauses. and these also include these pro-social values. So that was our first proposal in our article, to turn these abstract sustainability jargon to actual business practices. The second proposal is to incentivize responsible and sustainable business relation or business practices via promotive contract clauses. So like we remember, the proactive contracting approach, sorry, no, I did something, has two dimensions, so preventive and promotive. And this also means that promotive and preventive dimensions can be used in contract framing. So I will give you an example about this. So it means that the contract clause can be framed either preventively or promotively, even though the goal and the outcome of that particular clause would be exactly the same. So an example of a duration clause that could be framed either preventively or promotively. So a promotion framed duration clause would allow a party to unilaterally renew a contract on the condition that the other party performs well. Whereas then the preventively framed duration clause would be an early termination clause that would allow one party to unilaterally terminate the contract before its initial end date if the other party does not meet the pre-specified conditions. So basically the idea here is that the actual duration of the contract can be the same with both framings, but the framing would definitely have distinct effects on performance and the business relationship. And actually research suggests that preventive contract framing that highlights these obligations and penalties is better fit for mission critical exchanges and for exchanges where the relationship is not so important, while the promotive framing supports more exploratory, collaborative and long-term relationships. And also, for example, relationships where the distance is long. And these are all relevant for this corporate sustainability due diligence context as well. Then our third proposal is to engage end users in the contract design process, so that the purchase contracts and supplier codes of conduct would be designed in collaboration with at least first-tier suppliers or then with selected strategic suppliers. And like already mentioned, these information design facts and then principles and methods should be utilized in that process. And obviously, we also acknowledge that it's not always easy to actually do this, because a company can have thousands of first-tier suppliers even. But one option is to use these industry-wide initiatives on corporate sustainability contracting. And here are some examples of already existing initiatives, such as the Sustainable Terms of Trade initiative and the Chancery Lane project and the Amphori project as well. And here on the right side, I just wanted to show you an example of a contract that is designed for actual users. So this This is by Robert de Roy and his company, Creative Contracts, and they have designed an employment agreement for fruit pickers. Then I will maybe not go here now because we don't have that much time now. So I will just briefly show you our last proposal. So how to turn the sustainability jargon into actual business practices. So by preventing disputes, we should focus on dispute prevention, not on disputes themselves. And we think that already by our previous proposals, there shouldn't be that much disputes at all. But if disagreements still occur, there should be programs that guide the processes to evaluate and develop the collaboration between the contracting parties and to learn from past experiences, and also to identify problems and root causes. And once the root causes have been identified, the companies can prepare and implement a remediation plan that can encompass capacity building, technical and financial assistance. And also, of course, the contract clauses can then be adjusted to prevent future conflicts on the same issues. Then finally, a future area of application is for the proactive contracting approach is contracts and AI. So with my research team that includes many people from the University of Lapland and then some other universities as well. And like I already mentioned, Helena Haapio, then Soili Nyysten-Haarala, Jouko Nuottila, for example, and many others. Our dream is to have a research about the possibilities, costs, and risks relating to the use of computable language models. We all know about ChatGPT, I think, and we would like to study these in the context of designing contracts and legal documents. And we would like to focus on their need to be both legally functional and comprehensible for their users, whether the users are people or machines. And we would like to do this together with selected organizations, public and private, and utilize collaborative and explorative action research there, which means that we would design their contracts and legal documents together with the help of AI and see how that works and what risks and possibilities relate to that. And the goal would be, of course, to have access for all through AI and design. So basically that everyone can understand what they read and what they need to do when it comes to contracts. Okay, I think I used my time and now there is time for questions and answers.
Thank you, Anna, for your presentations. And
thank you. That was really insightful indeed.
And dear participants, if you want to ask something, you can raise your hand and I will unmute you, or just leave your question in the chat if you have any.
Let's wait a couple of minutes. Maybe people need to think a bit.
Yeah.
Or just type.
or it's just difficult. You need to get some time to understand.
Yeah, to absorb this.
Yes.
But Valentin or Maria, if you have some questions, you are of course welcome to. Okay, there is one.
Might it be legal to design a contract without the opportunity to cancel it?
Now I have to say that I'm not sure if I understand the question correctly. Could you maybe, Julia, if you can elaborate a bit on this question, like orally, if you would like?
I can wait a second. I asked to unmute here.
Yeah, maybe I can first answer to Peter's questions. So, are there any machine-readable format for proactive contracting? Unfortunately, not at the moment, I would say. In the future, if we get funding for this research project that I just mentioned, hopefully yes, at some point. But and we are now joining forces with some computer scientists as well. But our research group, for example, at the University of Lapland, we don't have that background, so we can't actually do the machine readable. So we really need this interdisciplinary or multidisciplinary collaboration in that as well.
The addition from Peter, XML and PDF free.
Yeah, of course, if you yes, that could be maybe a start, but maybe we head for or target for something more even, but that could be a starting point, of course.
Julia, if you want to ask something or comment your question, you can unmute yourself and ask it directly.
I suppose that the question is rather of a legal nature rather than contract design or something related to the main topic of our today's presentation.
Yeah,
because it's about the possibility of canceling the contract. So it's not about design, contract design. Contract design, as Anna mentioned several times during the presentation, it's rather about making contracts more understandable, comprehensive, etc. So it's not about making them one point way or eliminating a possibility to go away out of the contract.
Yeah, Julia now elaborates here. Yes, you are right. So actually, when you design a contract, it doesn't mean that that it would be not legally enforceable. It would be, obviously, but it would be only more understandable for its users. And there have been some questions, for example, if you include some images for contracts, that would the images, how would a court, for example, interpret an image in a contract? And there are no, to my knowledge, there are no court cases around that yet, but there is an article by, for example, Helena Haapio and then Vesa Annola about the interpretation of images in contracts, and they argue, and I know this as well, that courts are actually very used to use visuals in contracts as well, because many appendices of contracts include timelines and for example, these building plans and so on. So it shouldn't be a problem, and you can of course always say that if there's a conflict between a picture and text, the text will proceed, for example. So in that sense, it wouldn't be a problem. But of course, with this, if you use, for example, these AI tools to give an simplified version of a contract, then you might ask that which one would prevail, the original contract or the simplified contract, and that is to be seen.
Yes, thank you. I probably ask one question from myself. As I'm myself a corporate lawyer, I wonder if a contract design approach can be applied to extensive corporate transactional documents. Because I do understand that for an employment contract and employment documents that are directed to simple people that are not lawyers, it's a really good approach in order to make people understand what they sign and what they exactly need to do according to work organization rules, etc., etc. But if we are talking about complex transactional documents, is it possible to apply this approach successfully?
I think it's very possible and advisable. I do think that also in business-to-business contracts, the users would like to understand what they are, signing. And for example, in project business, the people who actually implement, who execute the contracts, they would need to understand what is what they need to do, and this contract design pattern library, it includes various patterns that can be used in business-to-business context, and one example is this delivery diagrams that are actually nowadays already used and have been used for many years in Incoterms. And those include visualizations of the delivery. So basically, they just visualize the text, and then, well, the business terms first. That was one example as well. Then you could use, for example, swim lanes. That shows who is responsible for what party is responsible for what, and plain language is also one to use in business-to-business documents as well, because according to proactive contracting approach, contracts should be used also as a script for a play in a way. So the idea would be that, because nowadays many companies first do contracts, and then they will, after the contract is signed, they will make a handbook of it. So like a
actually, I'm sorry for interrupting.
Yeah.
Actually, it's a common practice also for the European Commission. They first apply, for example, serious documentation, for instance, MiCA, yes, regarding the crypto assets. Then after a year or two, they make a handbook.
Yeah,
brilliant approach.
Yes, but how about having that already in the document?
No, they don't have time for this.
Yeah,
they need to see how it works in practice, to find people, the market participants, to put pressure on them, and then to realize how it should be actually working in practice.
Yeah.
So yes, it's a common practice, so there's nothing different.
Yeah, so our dream is maybe something different.
Correct.
Yeah.
Correct.
And actually we have more questions. We have like not many time, but anyway. You mentioned some literature about proactive contract theory at the beginning. Could you advise some more relevant sources?
Yes, I could. I actually wonder if it's somehow, I don't know if you plan to circulate these slides with the participants. I don't know if that's possible, but at least I have to mention the web page called lexpert.com. It's actually Helena Haapio's company. There is a brilliant page that includes various sources. And we are now actually currently, if you just Google proactive contracting, you will find many articles as well. And I hope that we will, during this year, maybe launch a web page that would include more sources. We are doing that at the moment because we have an international network for proactive law now, but the web page is not up and running at the moment. Okay. Then,
do we
Further
have
questions?
time? Yes, we have like one question is really long, and also some shorter one.
If Anna doesn't mind to answer,
we can take these.
Yes,
Okay. So what would be the priority task for RE in terms of contract drafting, such as ensuring contract is enforceable, making it easily readable, mathematically clear, using blockchain technology to perform contracts without further intrusion from the contract parties, like delivery of goods and service and payments?
Okay, this is a good question. I think for us, for our research team, it would be to make the contracts more user-friendly, so easily readable. We would not focus too much on this blockchain technology, for example. That's of course might be important in relation to some terms, and for example these payment terms, but this would not be our focus. Our focus would be how to use AI in helping to design more user-friendly contracts, and we would like to also study the risks, because there have been studies that suggest that, for example, this GPT-3 has an anti-consumer bias when reading and explaining consumer contracts. So it would be very important to also study those risks that relate to these technologies. I hope I answered to your question, because I still have.
It's also second part of the question.
Yeah.
Mm-hmm.
How can you simplify an EPC contract, which is usually 1,000? Yeah. That's a good idea. A good question. Again, this EPC contract, you have to start from somewhere. Again, in the contract design pattern library, for example, one pattern that came to my mind directly is it called contract map? So the idea is to actually use that pattern to see what all is included in the contract, what appendices, and how you could actually make those contract documents easier to read, and maybe not to have all of them anymore. So how to initiate really initiate a contract design process or contract pre-design process within your organization. So I really recommend you all to explore the contract design pattern library more thoroughly after this webinar at some point, because it's free and you can use it as you wish, and then adopt it to your own company's context and so on.
Well, it's actually a really typical question for a lawyer, because it's a common question whether we should simplify contracts or we should stick to the regulation. Because if we simplify contracts, then we lose something in terms of regulation. How we should do anything about it? It's difficult to lose this controlling mind of a lawyer when you do contracts.
Yes, well, that's a good question, of course, as well, and it depends. But I would still argue that oftentimes this very complicated language is not needed. Sometimes it is, and for example,
absolutely,
in the common law systems, some wordings that come from the case law, they might actually be needed, but at least in civil law countries, you don't have to use this express terminology so often.
Yes, because mostly many contract relationships are regulated by law, and we do not need to copy paste everything from the law. In comparison to common law areas where everything is based on the practice, the precedent, etc., where you definitely need to regulate more because there is no a certain law in place that would regulate it instead. So yes.
Yeah.
Maybe we should go for the next question if we have some time.
Yeah, so there is this question from Julia again.
Mm-hmm. Why do you think this approach is not spread wide in corporate contracting practice yet then?
Well, this might have to do with several reasons. I think one is, of course, that maybe there is not enough resources. This takes a bit time to actually implement. So, and many corporate lawyers are very busy. So this is really a project you have to start. So that might be one reason. Then, of course, there are some traditional views how the contracts should look, and then people might be also afraid and path dependent. So things have been like this for years. Why should we change this? And it's also a fact that almost more than 90% of contracts, whether they are traditionally drafted or not, they don't end up in courts, for example. So in that sense, there is no, because disagreements are handled outside the courts. So and companies and people within the companies are flexible, and they sort of fiddle around these problems. So in that sense, not all contracts need to be redesigned, for example.
Finally, we lawyers need to bill for something. If we do contracts on one page, then we will lose our income. So that's also something we should be thinking of.
Yeah,
and it is really difficult to lose money.
Yes, I agree and I understand, but then again, I would say that we should turn our roles from fighter in a court to designer that enables.
Exactly. We should think of how we can help our clients to make money.
Yes.
Rather than making money on them.
Yes.
That's a proactive approach, probably.
Yeah.
So let's take the last question. Does proactive contracting mean a more significant role of lawyers, not only in protecting, but also in a business developing now?
Yes, it means that. I think precisely what we discussed with Valentin just a moment ago. So from a fighter in a court to a designer, but proactive contracting also highlights the role, not just lawyers, but also the role of other, for example, business people, so business people, engineers, and so on, so that the contracts would not be understood just as a legal weapon, but also as tools to really communicate and tools for implementation and so on. So what I would like to highlight is the cross-professional collaboration, actually, that is needed anyway in business, I think.
Awesome. I think we ran out of questions. The last two messages were about just emphasizing the previous questions. And I think we should thank our today's speaker, Anna Hurmerinta-Haanpää, for her brilliant presentation and inputs into the proactive contracting. Thank you.